Legislative Assembly also can't touch the provisions that the state of Jammu and Kashmir and shall be an integral part of India. Can't touch that. It can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question. The proviso to Article 147 of the J&K Constitution says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable in relation to a state.
Yes.
Means a change in the Constitution of India. Whereas as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the
recommendation. Neither consent nor consent. It's a recommendation.
No.
Of the legislature.
Let's see 373. Let's see 373 for
yes,
a minute.
Please.
So really speaking, under 147 may have no application as far as, because you're not seeking to amend 370 but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly on the recommendation.
Yeah.
Let's assume so.
Let's
substitute. You're right. Recommendation.
Correct.
Let's substitute that word. Provided that the recommendation of the Legislative Assembly for the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, but let's kindly see what 147 says is the provisions of the Constitution of India.
You're not amending
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. For the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the state.
As applicable in relation to the state.
Which is why 370 is incorporated, Malad, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order. We're not talking about the Constitution of India here.
Sibal, doesn't it, I'm just thinking aloud,
yes.
Does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
yes,
you through an amendment cannot deactivate
that's all that
it.
we are saying. Nothing more.
Deactivate a provision which has already been applied to the Constitution.
That's all that we are saying. Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
As I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and you start
that's all.
And say that, look, okay, we don't want to make some of the Constitution provisions already made applicable, not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu and Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356. So now, Malaj, this is now the lay of the land as far as this is concerned. Now I want to take your lordships.
Simple is the factual lay, whatever you had to say is over?
No, Malaj, I'll go back because we are on the point of the Constituent Assembly and the Legislative Assembly. So Malaj, that has to be clarified. Malaj, a Legislative Assembly cannot be converted into a Constituent Assembly. My basic argument is that. Under what power can you convert a Legislative Assembly into a Constituent Assembly? Which is that power?
As a matter of fact, Praja Sabha was turned into a Constituent Assembly, 1951.
Well, there was a direct election, I believe, at that point in time. Praja Sabha was not all directly elected. But I'll check that out. But I don't want to make a statement, and I'm sure of it. No, there was not. I mean, I don't want to give an answer without being sure of it.
Unless you're sure about it.
That's right. I always hesitate to do that. My learned friends are far more, articulate on those issues than I am. Well, according to me, and I'll give that date, why should I say anything? The Constituent Assembly was directly elected in Jammu and Kashmir, but I don't want to, I must be sure of it before I say that. I know it says that Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution. So I was aware of it, but I was not sure where it was. I just wanted to mention. Unlike us, we were indirectly elected, our Constituent Assembly. Well, the argument was that when the Constitution in 368 talks of amendment to the Constitution, it's a procedural argument. Where does the constituent power lie? That was the argument, and that in that context, the issue of what is a Constituent Assembly,
yes,
that is discussed. It's in that context because we're dealing with that issue. It has been suggested that on every occasion the procedure is followed as laid down in Article 368 by the two houses of Parliament and the assent of the President is given, there is the reproduction of the functions of a Constituent Assembly. Just mark. In other words, the Parliament acts in the same capacity as a Constituent Assembly when exercising the power of amendment under the said article. This is fundamental to the entire argument that I'm making. So you have a clear distinction between the exercise of constituent power and the exercise of legislative power, which is what I said in the beginning to your lordships. Parliament, while enacting a law, functions within the contours of the Constitution. A Constituent Assembly has no constitution in place. It has every right to do what it likes till such time as the Constitution is framed. So at no point in time in law can a legislative assembly be converted into a Constituent Assembly as a matter of law. Luckily, we had no Maharaja exercising his powers with us. We had Parliament doing that.
And
now,
even when Parliament amends the Constitution,
yes,
it's not exercising powers as a Constituent Assembly.
That's correct.
It may be exercising a constituent power.
That's correct.
The power to amend. But because it's a power which is restricted, you are subservient to the Constitution.
That's right.
And therefore, you're bound by the provisions of the Constitution, by virtue of which your power to amend the Constitution is circumscribed.
That's what I said at the outset, Malas. That has been my submission throughout. Otherwise, Malas, see the danger of this argument. Tomorrow, Malas, Parliament says that we are the Constituent Assembly. They can do away with basic structure.
Dr. Ambedkar also spoke about it in his speech on 25th of November, 1949.
I'm sorry, but I didn't get your note.
Dr. Ambedkar,
Yes.
while presenting the final draft
Yes.
on 25th of November 1949,
Yes.
also spoke about this aspect.
Yes. Yes.
In his
Yes,
concluding
I think
speech.
we have it, I think. We have it, I think, in volume 8. I'll just come to that. No, the point I'm making is a more fundamental point which impacts the future of our country. If you, in principle, say that a parliament can convert itself into a constituent assembly, then where do we go from there? Forget about this case. I'm far more worried about our future. Parliament can never say that, because that constituent assembly is a political process, which I said at the beginning. It's a political process in the context of the aspirations of all those participating in the constituent assembly as to what the state should be like. How do you meet the aspirations of the different segments of the community which have to be met, and what kind of provisions should be put in place? So it's the genesis of the politics of the day which determines what kind of constitution we want. Which is why, when you talk about diversity, when you talk about minorities, we talk about Dalits, we talk in our constitution, what were we faced with? In 1947, what were we faced with? We were faced with a situation where disparate communities, diverse communities, different religions, different races came together to be part of the Union of India. And their aspirations had to be met. So you had provisions with the Dalits, you have provisions with the minorities. You have provisions dealing with reservations, the scheduled castes, the scheduled tribes. That's a political process. That's why our constitution is what it is. Unlike, as I told, in Europe, it was an entirely different process. Here it was an amalgamation of colors to be united as one, which is the Tiranga. That's what it is. You can't convert a legislative assembly into that process.
But equally, Mr. Sibal, to completely divorce the power of amendment from the political process inherent in the amending power
Yes, of
would
course.
not be appropriate, because there's no strict dichotomy in that sense between the exercise of the constituent power itself being traceable to the political process and the power of a constituent assembly being entirely political in its nature. The constituent power itself of Parliament to amend the Constitution is a political power.
I agree entirely. Absolutely right. We're not saying you can't amend. Because it's not our case. You can.
But when Parliament amends according to you,
Yes.
it is not exercising the powers of a constituent assembly.
That's all that I'm saying. That's all that I'm saying. It's not converting itself. And then it has to function within the Constitution of India. I'll come to that later. We're at a stage, Malaz, where a CO is issued.
The Constituent Assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. Absolutely. Absolutely, Malaz. And the judgment says so, Malaz. That it's not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. I'm not Malaz being political, but that's the worrisome part. May I reach 6:20, Malaz?
20.
So, Malaz, when your lordships talk about temporary, Malaz, really you have to look at the constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been.
This is a marginal
To
note.
the other
There's no
side.
question about it. It is a marginal note.
Yes. So, Malaz, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
But there's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and
But those
special
are
provisions.
Malaz, I'm not disputing that. These are all different provisions, Malaz.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Malaz, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there. Issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. If you look at the heading, Malaz, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercised the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves, and abrogated 370. Unique, constitutionally a unique, unheard of, a procedure that is unknown to law, because the objective was entirely different. And I've been saying that from day one.
To apply the proviso to clause 3 of Article 370.
Yes, yeah, because they understood it that way, that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly,
Yes.
by virtue of the fact that the Legislative Assembly has been dissolved.
Yeah.
Assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
That's right.
Now that it has been dissolved,
Yes.
under 356, Parliament has the power to make laws with all aspects of whether it's list 1, list 2, or list 3. And then they exercise the power under the proviso.
That's right. That's right. So, actually, they understood 370 sub-article 3 in the manner in which I am stating before your Lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, so that now your Lordship knows the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies.